I need just an extra minute. My machine just fell over. I need to put it back in.
Good morning. Before I call the case, I know that our court reporter might need an extra minute, so let me just check in. Tracy, do you
Good to
need a few
go.
more? You're good to go? Okay.
Yeah.
Great. All right, now calling proceeding number 25G-0289EC. This is the Colorado Public Utilities Commission versus Dial Car Service LLC. This hearing was scheduled on August 21st by decision number R25-0609-I. My name is Melody Mirbaba, and I am the administrative law judge who was assigned to this case. It is now October 16th, 2025 at approximately 9:00 a.m. I'll just let you all know that consistent with commission practice, we are recording this hearing. We also have a court reporter taking down everything being said. And we are webcasting live both the video and the audio of this hearing, and that will continue during any breaks that we take. So please do keep that in mind. Just to ensure a clear record, I'll have everybody keep your microphones muted until it's your turn to speak. And we're at that point now. So let me find out who we have here today. I'm going to start with Colorado Public Utilities Commission trial staff.
Good morning, Your Honor. Excuse me. Assistance Attorneys General Jennifer Hayden and Aileen Chong appearing on behalf of trial staff for the Public Utilities Commission. With us today are investigators Aaron Hazlett and Amy Roth of trial staff and Supervisor Lloyd Swint.
All right, thank you. Do we have anybody here present on behalf of Style Car Service LLC who will either refer to as Style Car or respondent? I'll just note that when I look at who has appeared, at least on the Zoom screen, I don't see any names that indicate there's somebody here for a respondent. So I'll pause just to see if I've missed anything here. And if there is somebody here for a respondent, to go ahead and unmute yourself and speak up. Ms. Hayden, has staff at all heard from respondent or received any indication that respondent intends to participate in this
No, Your
matter?
Honor. No, Your Honor.
Okay. All right. It is about 9:02. I'll give the respondent the benefit of the doubt that the respondent is attempting to join us and maybe having a technical problem. On occasion, that can happen. And usually what we'll do is we'll just wait a little bit. It's 9:03 right now. I think, why don't we wait until 9:15? And if the respondent has not joined us, then we'll go ahead and proceed from there.
Thank you, Your Honor.
We will be in recess until 9:15. And again, the webcast will continue during that time. Okay, we'll go back on the record. Let me just see if we've got anybody who has appeared while we waited on behalf of Style Car Service LLC. Okay, I will just note for a record that nobody has spoken up as having appeared on behalf of the respondent. And just looking at who we have here in our Zoom meeting, there does not appear to be anybody here on behalf of the respondent. It is now 9:16. I think we've waited an appropriate amount of time for the respondent to appear. And so I want to go ahead and proceed with our hearing. Before we get started on the evidentiary portion of the hearing, I just want to check in with staff. First of all, are there any preliminary matters that we should address first?
Yes, Your Honor. Staff does have one preliminary matter. Staff
Sure.
moves for an entry of default against the respondent, Style Car Service, LLC. In conjunction with that motion, staff moves to vacate this hearing. In support of this motion, Commission Rule 1001 states that where not otherwise inconsistent with Title 40 or these rules, an administrative law judge may seek guidance from or may employ the Colorado Rules of Civil Procedure. Staff is respectfully requesting that Your Honor employ the Colorado Rules of Civil Procedure and enter default against the respondent under CRCP Rule 55A.
And is that the sum and substance of the legal authority you want to cite in support of your motion?
No, Your Honor, I can go on. Specifically, CRCP Rule 55A states when a party against whom a judgment for affirmative relief is sought has failed to plead or otherwise defend as provided by these rules, and that fact is made to appear by affidavit or otherwise, the clerk shall enter his default. Here, the respondent has failed to appear at this hearing, failed to make a filing required regarding respondent's representation by the ordered deadline of October 2nd, 2025, and has failed to appear at any point otherwise in this proceeding. For judicial economy and to save time and resources, staff moves for an entry of default against the respondent and moves to vacate this hearing. Additionally, if Your Honor grants staff's motion for entry of default and a motion to vacate this hearing, staff will promptly file into the e-filings a motion for default judgment, supporting affidavits to comply with CRCP Rule 55B and CRCP Rule 121, Sections 1 through 14, which are the statewide and local practice standards for motions for default judgments. CRCP 121, Sections 1 through 14, set forth the requirements to establish a factual basis for the CPAN through supporting affidavits. As required, staff will file the supporting affidavits that include showing a valid service, which the court in this case has found in decision number R25-0609-I that staff had timely filed its affidavit and attachments that included detailed information about how the CPAN was served on the respondent in this matter. The Commission's discussions and findings in that decision found that staff properly served the CPAN on respondent by sending the CPAN by certified mail to respondent's designated agent at the address on file with the Commission. The subsequently filed affidavits will support that venue is proper, that the respondent is a business, that respondent is neither a minor, incapacitated, or officer or agency of the state of Colorado, and supporting research results that show not active in military service. Finally, staff will file a proposed order and judgment in favor of staff and against respondent, which is also a requirement of CRCP Rule 121, Sections 1 through 14G. In summary, staff's motion contains these parts. Staff moves for an entry of default against the respondent and to vacate this hearing.
Okay.
Second. Okay.
I think I can rule on this. I'll start by saying I applaud your creativity. And this might be something that the staff could more appropriately seek out in the future. But let me point out a couple of things. So if I'm going to rely on the rules of civil procedure to get to default judgment, then we need to see some sufficient parity between where the rules of civil procedure allow for a default judgment, parity in how that works, and parity in how we do complaint. If you look at the CPAN, nothing in our CPAN says anything about default judgment being a possibility. We don't have a summons and complaint process like they do in regular court proceedings, whereas that is very clear that if you do not file a response, you do not answer, default judgment may be entered against you. That is not what we have with our CPAN. I pulled up the CPAN. I took another look just to see, is there anything in here that is going to advise somebody that if they don't answer and they don't respond, that a civil penalty in the full amount may be assessed against them? And I don't see it. You can certainly tell me where that is. There's nothing in there about filing a complaint, filing an answer, you know, in a case like this. So staff may want to consider how you get to where we can rely on the rules of civil procedure for default judgment. We need to have a process that is more similar to that in county court for this kind of a case. So I'm going to deny it based on that. I would also point out that if this is something the staff wants to look at in the future, you need to consider whether the complaint would provide enough information for court to rely upon to give you the judgment in total of what you are seeking. And I don't know that it does. In courts, complaints have to have, I mean, we do have a sort of a notice type complaint process in Colorado where it doesn't need to be overly detailed, but there does need to be enough. And I would question, frankly, whether our CPANs meet that, even that low threshold. So that's something for staff to give some thought, and I certainly applaud staff for trying to find some efficiencies, but we're not there yet. And so I am going to deny that request. I will put that in the written recommended decision that comes out. So with that, I just want to see, do you have anything you want to add based upon the ruling that I just made, or anything else that we should address before we get started?
No, not at this time, Your Honor. Thank you.
Okay. All right. So let me just see if there was, I might have had one thing on my list. Oh, since we've got you, Ms. Hayden, and Ms. Chong both appearing, I'm just wondering how you guys are planning to divide up the work during this hearing, because it'll just help me to streamline things.
Your Honor, this is Aileen Chong, on behalf of trial staff. I will be conducting the direct examinations of Aaron Hazlett and Amy Roth.
Okay, and hold on, I had your witness list open. Let me just pull that up really quick. Okay. All right, staff may call your first witness.
Thank you, Your Honor. And before calling our first witness, staff would request that the judge today take administrative notice that service of the CPAN in this case was properly served on the respondent, and that rendered the CPAN ripe for a hearing. And this is per decision number R25-0609-I. So we would just ask the judge to take administrative notice that service was proper in this proceeding.
I don't know that I need to take administrative notice. I've already made a direct finding of that in a prior decision. It wasn't in the ordering paragraphs because there's not much. It's just a finding. So the finding has already been made. It's a decided issue, and I certainly plan to rely upon that in the recommended decision that I issue. So I don't know if administrative notice is necessary for that, since it's already been a factual finding.
Okay, thank you for that information, Your Honor. At this time, staff would call investigator Aaron Hazlett to the stand.
Hi there, investigator. If you could just raise your right hand with me. Do you swear or affirm that the testimony you're going to give in this case will be the truth?
Yes, I do.
Please state and spell your name.
My name is Aaron Hazlett. It's ERINHAISLETT.
Okay, before we get started, let me just give you a couple of advisements since we are all appearing via Zoom. You are not allowed to receive assistance from anybody during the course of your testimony. You're really only allowed to look at documents to aid you in your testimony when directed to do so by counsel or by me. If you have copies, physical paper copies of the exhibits in front of you and are directed to look at exhibits, you are welcome to look at the paper copies of those. They will be displayed on the screen as well, but if the paper copy is easier for you to read, you may do that. Do you understand these advisements and agree to follow them?
Yes, I do, ma'am.
Okay, Ms. Chong, you may begin your examination whenever you are ready.
Thank you, Your Honor. Good morning, Ms. Hazlett.
Good morning.
Where are you employed?
I work for the Public Utilities Commission for the state of Colorado.
How long have you been employed there?
4 years next month.
And what is your position?
I'm a criminal investigator for the transportation section.
What responsibilities are included with being a criminal investigator?
We investigate carriers that we regulate, such as towing carriers, limo carriers, Uber and Lyft, such like that. So,
Do you have any prior work experience in law enforcement?
I've been in law enforcement for about 26 years, investigator with the Air Force, Department of Defense. I was a property crimes detective in Texas and then here. So.
Thank you, Ms. Hazlett. And I want to jump into what brought us to hearing today. Could you please tell us how you came to be assigned to the case that brings us to a hearing today?
So it was a little bit unusual. So we conducted a enforcement operation at the airport, Denver International Airport, and we were there to contact carriers that were there. And I had mentioned to our group of investigators, hey, if anyone sees style car service, they are inactive. So please let me know, or please, make notice. And when we were kind of discussing it with the group, the Walker Sears, who's the supervisor for commercial transportation at the airport, he overheard my conversation and he came over and said, style car probably will not be here today, but they are operating at the airport. And he just mentioned it like that. The rest of the day, I didn't see style car service, but we kind of hopped around from the commercial holding lot to the airport, and I didn't see every single car, but I didn't see style car. And then after the fact, Walker Sears had sent an email to Lloyd Swint, my supervisor, and that was forwarded to me with communication back and forth between Walker Sears and the owner for style car service.
Okay. And just to follow up on a couple details, you mentioned an enforcement operation. When did that occur?
That occurred on June 6, 2024.
And can you give us a little bit more background about what this enforcement operation was for?
So we contact carriers at the taxi carriers, limo carriers, and shuttle carriers at the airport to make sure that they have the proper identification, the proper requirements that they're supposed to have when they're operating as a commercial vehicle. So we just kind of make sure they're doing what they're supposed to.
So prior to this enforcement operation, were you familiar with the Respondent Style Car Service LLC?
Yes, I was.
How were you familiar with them?
I was assigned a case a couple years ago and regarding safety violations, and I investigated them, eventually went to hearing, and then they were granted a decision, and then they never paid the decision, the fine, and they stayed inactive.
Okay. So at this enforcement operation, why did you believe that Style Car Service was still operating?
I just kind of had that feeling that the owner for Style Car Service doesn't care about the rules, and he just keeps operating without a permit. He continued to operate even after his permit was inactive for my last case. So I just kind of had that feeling that they could be.
And you had mentioned Walker Sears. Can you tell us what is his role at DIA?
So he's a supervisor for all commercial vehicle traffic. So he deals with the taxis, the limos, and all the shuttle traffic that goes in and out of the airport.
Okay. So he would have information about the those particular carriers who are going through DIA.
Yeah, he had, because each of the carriers have to be registered with the airport to operate.
Okay. And you stated that Walker Sears had a conversation with the respondent, correct?
Yes, he had mentioned that he had had conversations for the past couple weeks or months regarding his stall car services operating at the airport and what they had to have and what they didn't have. So,
Okay. And was that via email?
yes. And
As-
I believe through phone calls and in person too.
Okay. As part of your investigation, were you forwarded those email correspondences?
Yes, I was.
Can we please pull up what's been marked as staff's hearing exhibit number 113? If we could scroll through the entire document. And while we're scrolling, Investigator Hazlett, what is this?
This is the email that I was forwarded by my supervisor, Lloyd Swint.
And who are the parties that are emailing in this correspondence?
Walker Sears and Gary Vendrell, the owner for Style Car Service.
So you recognize this exhibit?
Yes, I do.
Are correspondences with respondents kept in the ordinary course of regularly conducted business by the PUC?
Yes, they are.
Your Honor, at this time, staff would move to admit what's been marked as staff's hearing exhibit number 113.
As we don't have a respondent with us, and we still don't have a respondent, I'm not sure I should bother asking if there are any objections, but I'll just go ahead and do that in case somebody happens to join us, Are there any objections to the admission of hearing exhibit 113? There being no objection, hearing exhibit 113 is admitted into evidence.
Thank you, Your Honor. Ms. Hazlett, can you please summarize for us what you learned from these email correspondences?
That Gary Vendrell had communication with Walker Sears about his lack of registering his vehicles at the airport, and Walker Sears was making note to him, telling that if he wants to continue to operate at the airport, he has to provide insurance information and have his vehicles tagged with the AVI, which is a requirement for the airport to have for each vehicle that operates to and from the airport. And then Walker Sears also made note that his Department of Transportation and permit were not active.
Okay. Could we please scroll to page 3? Thank you. And did Mr. Sears also make respondent aware of the lack of a PUC permit?
Yes, he did.
Okay, and you see that on the top of that page?
Yes.
Okay. And at the bottom of page 3, does, in that correspondence at the bottom, does Mr. Sears make Mr. Vendrell aware again that he has a lack of PUC authority?
Well, all he says is he just has current information, and that he just responds. He never accepts that he doesn't have a PUC authority, but he responds to the email from Walker.
Yep. And then below Mr. Vendrell's response, we see another email from Mr. Sears. In that message, does Mr. Sears indicate that the respondent does not have PUC authority?
Yes, he brings it up again that he doesn't have PUC authority.
Okay, counsel, I'm going to stop you. I tried to give you a little bit of leeway to see if you were leading somewhere, but just to have your witness acknowledge what is in evidence already, what this document says, it's already in evidence, it does not help. It is a cumulative evidence. In other words, you're repeating evidence that's already in the record unnecessarily. So I'm not going to allow that. But if you want to ask your witness specific questions about the document, that's not merely acknowledging what the document says, that's perfectly fine. But I don't need you to ask her what the document says. I can read it and it is in evidence.
Understood. Thank you, Judge. Miss Hazlett, so based on your review of this correspondence, was it your understanding that Mr. Vendrell, the respondent in this case, was aware that he did not have PUC authority to be operating his business?
Yes.
Okay,
Yes.
we can pull this exhibit down. And Ms. Hazlett, as part of your investigation, did you conduct an initial search within various databases to find information on Style Car Services?
Yes, I did.
Which databases?
I looked at our internal database. It's called IFMS. I looked at Secretary of State, and I also looked at FMSCA database.
And I want to start off with IFMs. Can we pull up what's been marked as staff's hearing exhibit number 100, the public version? And can we please scroll through this document? Ms. Hazlett, what is this?
That is like a printout of the stock car services record in the IFMS database.
Do you recognize this exhibit?
Yes, I do.
How are you familiar with this exhibit?
I pulled and saved the document to the report.
Are entries in IFMs made as part of the regular practice of the PUC?
Yes, it is.
Are entries in IFMs kept in the ordinary course of regularly conducted business by the PUC?
Yes.
And when did you access this document?
June 13th, 2024.
Okay.
Could it be
Your Honor,
blown
at this
up a
time-
little bit? I'm sorry. Could it be blown
okay.
up just a little bit? Sorry.
Yep, happy to zoom in if it's too small.
Or is that okay?
It's good. Thank you.
Your Honor, at this time, staff would move to admit what's been marked as staff's hearing exhibit number 100, the public version, as well as the confidential version into evidence.
Right, hearing exhibit 100 and hearing exhibit 100C are admitted into evidence.
Thank you. Can we please scroll to page 4 of this exhibit? Ms. Hazlett, who is the designated agent in this case?
It's called registered agents.
And what is the email address for the designated agent?
It's Gary@stylecarservices.com.
What is Gary Vendrell's capacity in Style Car Service?
His relationship, a member/partner.
Okay. And scrolling up to page 2. What was Style Car Service LLC's permit status at the time you looked this up?
Inactive.
And since when was Style Car Service's permit status inactive?
Their status went inactive on 5/24/2023.
Has respondent made efforts to apply for a permit?
They applied for a permit just before the permit expired. I say maybe a week before the expiration.
And around what time was that, or what was the date?
I am guessing maybe 5/17. I could be wrong. 5/17/23, but I could be off a couple days on the date.
What were the results of that application?
It was dismissed.
And why was it dismissed?
It was dismissed because of they hadn't a CPAN that was pending that they hadn't paid.
Okay. And by they, you mean respondent?
Stock car service, yes, I'm sorry.
Could we please scroll down to page 6? Thank you. Does the IFMs indicate respondent's history of insurance?
Yes, it does.
And when was the last time that respondent had an active insurance policy?
It expired on 6/30/2023.
Okay.
So that was effective between about a year before that.
Thank you. We could pull this exhibit down. And can we next please pull up what's been marked as staff's hearing exhibit number 101? Investigator Hazlett, what is this?
It's the record for Secretary of State for Style Car Service.
Do you recognize this exhibit?
Yes, I do.
And how are you familiar with this exhibit?
I pulled the document and saved it to the file.
Is researching respondents via the Secretary of State database a regular practice of the PUC?
Yes.
Your Honor, at this time, staff would move to admit what's been marked as staff's hearing exhibit number 101.
Hearing exhibit 101 is admitted into evidence.
Thank you. Investigator Hazlett, what did you learn from this Secretary of State entry?
At the time I pulled the record, they were non-compliant.
And what does it mean to be non-compliant?
They didn't provide, or they didn't update their forms that they were supposed to by the date they were required to.
You could pull this exhibit down. Investigator Hazlett, did you also look up a respondent in the Safety and Fitness Electronic Records, otherwise known as
Yes.
SAFER?
Yes, I did.
What is SAFER?
So it's a Department of Transportation Federal Water Safety Carrier Administration record for different carriers that have a DOT.
Why did you look respondent up in this database?
Because they're operating through the airport. So if they're operating through the airport, just through the airport, it's considered interstate travel, and they can operate to and from the airport through interstate travel.
And what are the implications for your investigation if respondent is regulated by the Department of Transportation?
If they have an active DOT, they don't have to have a PUC if they're just taking passengers to and from the airport. So they don't have, like I said, they don't have to have a permit.
Okay. Was that the case for respondent?
No, their DOT was not active.
Okay. Can we please pull up what's been marked as staff's hearing exhibit number 102? And as we're scrolling, Investigator Hazlett, what is this?
Do you mind making it a little larger, please? This is the printout of their Department of Transportation DOT number for stall car service.
Do you recognize this exhibit?
Yes, I do.
How are you familiar with this exhibit?
I pulled the document and saved it to the file.
Is researching respondents via the SAFER database a regular practice of the PUC?
Yes, it is.
Your Honor, at this time, staff would move to admit what's been marked as staff's hearing exhibit number 102.
Before I admit this, and you might have answered this, okay. And just looking at the document, I just want to get the date of the document accurate. I think it says the only date I can see is June 12th, 2024. Is that when this document was pulled? The June 12th date is in there a couple of times. It's just helpful when I'm admitting the document to know when it was pulled. Ms. Hazlett, do you remember if that's the date, or if there's a different date that this was pulled?
That would be the date that I pulled the document, because it was right around the same time after the DIA enforcement. So that date sounds about right, yes.
Okay, hearing exhibit 102 is admitted into evidence.
Thank you, Your Honor. Investigator Hazlett, what did you learn from this SAFER entry?
That their DOT number was out of service.
And how did knowing that impact your investigation of style car service?
It just helped that so this would require them to have a permit to offer transportation in the airport, and obviously to have intra-state travel also.
Thank you, and we can pull this exhibit down. And Investigator Hazlett, I want to next turn your attention to the factual bases of the violations in this case. Did your team initiate a sting operation against the respondent?
Yes.
Can you please tell us what the general plan for this sting was?
General plan was to kind of confirm my thoughts that they were operating intrastate travel for compensation. So I set up kind of like set up like a girls' night where they would pick up a party in Loveland and take them to Red Rocks and then take them back to the address in Loveland. So it would be all intrastate travel. So all I wanted to get was a quote and not an actual confirmed trip.
Okay, and this would be done under an alias.
Correct.
And did you yourself reach out to respondent with this fictitious ride?
No, I did not.
Who did you have do that?
I had one of my colleagues, another investigator, use her alias because mine was used already for the previous investigation that I had a couple years ago.
Okay. And was that investigator Amy Roth?
Yes, it is.
Okay. And did you yourself write the message that investigator Roth would use to contact the respondent?
Yes.
So her actions were under your direction?
Yes.
And did investigator Roth receive a response to her message from the respondent?
Yes, she did.
On what date did she receive a response?
It was 6/18/2024.
Can we please pull up what's been marked as staff's hearing exhibit number 104? Thank you. Investigator Hazlett, what is this?
This is the email that Amy Roth received to her alias email from Gary from Stout Car Service.
Do you recognize this exhibit?
Yes, I do.
How are you familiar with this exhibit?
She forwarded it to me after she received it, and then I saved it to the file.
Are correspondences with respondents as part of investigations kept in the ordinary course of regularly conducted business by the PUC?
Yes.
Your Honor, at this time, staff would move to admit what's been marked as staff's hearing exhibit number 104.
Hearing exhibit 104 is admitted into evidence.
Thank you, Your Honor. Investigator Hazlett, did a respondent indicate that he would be able to complete this ride?
Yes, he did.
And in doing so, was the respondent offering to operate a luxury limousine in interstate commerce?
Yes, he was.
Thank you. We could pull this exhibit down. Investigator Hazlett, you previously testified that respondent's permit was inactive due to expiration on May 24th, 2023, correct?
Yes.
And it had not been renewed since then?
No, it had not.
So on the date of respondent's reply, June 18th, 2024, did respondent have an active permit?
No, he did not.
And you had previously testified that the respondent last filed insurance with the commission for a policy that was canceled on June 30th, 2023, correct?
Correct.
So on the date of respondent's reply, June 18th, 2024, did the respondent maintain and file with the commission evidence of financial responsibility?
No, he did not.
Based on your investigation, did you issue a CPAN?
Yes, I did.
Could we please pull up what's been marked as staff's hearing exhibit number 105?
Sorry, it's giving me a little bit of trouble loading. Give me a second.
No problem, thank you. Investigator Hazlett, what is this?
That is the CPAN that I issued to Stout Car Service.
Okay, can we scroll through each page? So you recognize this exhibit?
Yes, I do.
And how are you familiar with this exhibit?
I created the document.
Are CPANs made as part of the regular practice of the PUC?
Yes, they are.
Are CPANs kept in the ordinary course of regularly conducted business by the PUC?
Yes.
Your Honor, staff would move to admit what's been marked as staff's hearing exhibit number 105.
Hearing exhibit 105 is admitted into evidence, and I'll just note for the record, rather than every time asking if there's an objection, since it doesn't appear we have a respondent, I'm usually just pausing here and just double checking to make sure nobody new is joined. So just so you understand why I'm pausing in between every time you ask, and I just wanted to make that record that I am continuing to look to see if we have anybody joining us. So again, hearing exhibit 105 is admitted into evidence.
Thank you, Your Honor. If we could scroll up to the first page, please. Investigator Hazlett, what are the violations that you charged respondent with?
Failure to maintain evidence of financial responsibility and operating or offering to operate as a limited regulation carrier in intrastate commerce without having a permit.
And why is it important for respondents to have an active permit?
The state law requires it, and also it confirms that they do what they're supposed to. If they have a permit, they'll do all the other requirements that law requires. Sorry.
Why is it important for respondents to have active insurance filed with the commission?
That they have insurance, and this confirms it if they file it with the commission. And insurance is never know what will happen on the road. Safety.
Investigator Hazlett, did you mail this CPAN via certified mail to the respondent?
Yes, I did.
Could pull this exhibit down. Investigator Hazlett, are you aware of any prior proceedings against respondent?
Yes, I am.
And were you the investigator on that prior proceeding?
Yes, I was.
What were the circumstances of that case just generally?
Generally, it was safety violations and lack of following the rules and regulations.
Did this case go to a hearing?
Yes, it did.
When did it go to a hearing?
December 12th, 2022.
2022?
2022, yes.
Was there a decision made in that case?
Yes, there was.
Could we please pull up what's been marked as exhibit number 111? And Investigator Hazlett, what is this?
This is the decision for the case we were just talking about for stock car service.
Okay. Do you recognize this exhibit?
Yes, I do.
How are you familiar with this exhibit?
I reviewed it after the decision was made, and then I saved it to the case file.
Are decisions written as part of the regular practice of the PUC?
Yes.
And these decisions are kept in the ordinary course of regularly conducted business by the PUC?
Yes, they are.
And could we just scroll through the entire document? I know it's 67 pages, but just to make sure we can take a look. And Your Honor, while we're scrolling, staff would move to admit what's been marked as hearing exhibit number 111 into evidence.
Hearing exhibit 111 is admitted into evidence.
Thank you, Your Honor. And we can stop scrolling. Could we please pull up to page 1 of this exhibit? Investigator Hazlett, when was this decision published?
It looks like June 29, 2023.
And scrolling down to page 65, looking at paragraph 2, what was the judge's decision from this hearing?
paragraph 2, that style car was assessed a civil penalty due to certain counts of the CPAN. And they were given a civil penalty and surcharge of $20,000.
And that's due to violation of those particular violations, correct?
Correct.
Okay.
Yes.
And has respondent paid this civil penalty?
No, they have not.
So to date, they've never paid the civil penalty.
No, they have not.
Okay. And from your recollection, what findings did the judge rely on to make this decision?
Do safety violations.
Yeah. Let me stop you there. I wrote the decision, and the decision is in evidence. And so I will certainly reread my own decision. And I don't need Ms. Hazlett to tell me what was relied upon. It's all in writing anyway. So, but you're certainly welcome to ask her questions about it. I just don't need her to tell me what's in evidence already, particularly since the decision that I wrote myself.
Understood, Your Honor. We could pull this exhibit down. Investigator Hazlett, what are your recommendations today?
That they be assessed the full penalty and given an order to cease and desist.
Thank you, Investigator Hazlett. Staff has no further questions for this witness.
Okay, just give me a moment. There's a chance I might have a question or two. You know, just starting with this last exhibit, let's pull it back up. What number was that? That was 111. And that was a decision number R23-0430. It's already been admitted into evidence, but I just want to get one thing clarified. Ms. Hazlett, this looks like there was a modification made to this decision, just nothing significant, but let's go to page 2 of the exhibit. Okay, actually scroll down to page 3, just to make it a little bit easier. Okay, so if you see there at the top of that page, there is the header that normally appears on our decisions that includes a decision number and a proceeding number. It's not there. And to me, what that means is that this document has been somehow modified to remove the decision number, the normal standard header that we see on every single page of every recommended decision or any interim decision. We always have that header at the top page, and I don't see that there. Ms. Hazlett, do you know what happened here?
To be honest, I pulled it from our the pay God, I can't think of the name of it, where we get all e-filings. I pulled it from e-filings. So I didn't do anything wrong. I just pulled it from there.
Oh, I'm not accusing you of doing anything wrong. I looked at the exhibit before I admitted it, and I don't think that there's anything substantively that was modified. It's just perhaps the header was removed to make it easier to mark the exhibit as an exhibit as required. It just seemed like that's not how we do our exhibits. Hold on just one moment. I just want to see if I can figure one thing out before I move on from this subject. Okay. I will probably have to ask counsel to try to shed light on what happened, but Ms. Hazlett, it's your testimony that you pulled hearing exhibit 111, which is decision number R23-0430 from the commission's e-filing system, and that's the document that was used to create hearing exhibit 111. Is that right?
That's correct. I mean, that's where I get anything that is published.
Okay.
So sorry.
And is it fair to say that you are not the one that actually marked the exhibit and prepared it for filing in our case?
That is correct. I did not do that part.
Okay. Do you know was it somebody at the AG's office that helped you with that?
I would have to confer with Aileen on that because I'm not sure who did that.
And I'll be clear, I am not asking for any kind of privileged information. I'm just trying to figure out whether the AG's office will be able to clarify this.
Yeah, I don't put any of the hearing exhibits forward, so I didn't do that part.
Okay, thanks. Let me just take another quick look at my notes. Okay, so we can pull this exhibit up. I don't know if it'll be necessary, but we discussed hearing exhibit 102, which is the record that you pulled up from the U.S. Department of Transportation to determine if respondents' U.S. DOT permit was active. And and we figured out that that was pulled. Yeah, let's have it up there. As of June 12th, 2024. And I recall your testimony that one of the reasons you pull this up and you look for this is to determine whether they need a PUC permit if they're simply operating in and out of the airport. So I am just wondering, did you go back and search US DOT records as of June 18th, which is the date of the CPAN violations, to determine whether, as of that date, respondent still did not have an active US DOT number?
Yes, and I have looked up since then, and you can't even pull the record up anymore because they're just out of service. It won't even print that page that you see now. It just shows them out of service. So they never got they never reactivated their DOT.
Okay, that's really all I had to ask. And counsel, do you have any redirect?
Yes, Your Honor, we could keep this exhibit up. Oh, sorry. If we could please pull up exhibit number 102. Ms. Hazlett, you had a discussion with the judge about when the respondent in this case's DOT permit under SAFER was out of service. If we could please zoom in onto page 1. Scroll down a little. Do you see the portion in the top of that first box that says out of service date?
Yes.
And what date does that say?
4/27/2024.
Okay, so what does that indicate to you?
That they've been out of service since 4/27/2024.
Okay, and we could pull this exhibit down. And I have no further questions.
Okay, Ms. Hazlett, thank you for your testimony. That will conclude your testimony, at least for now, unless counsel decides to recall you. Thank you so much. Before we move on to the next witness, counsel, I'm hoping you can clarify how hearing exhibit 111 was prepared.
Yes, Your Honor, and I am tracking what Your Honor was noticing about those decisions, and I do not have an answer for you right now with regards to why that header is not present on our hearing exhibit, but I can figure out what's going on and then follow up with the court in a filing.
Sure. I mean, I'll just say substantively, there isn't anything else about hearing exhibit 111 that I would question. It really does appear to be an otherwise very accurate, but that's a red flag for me when I know how our decisions are written, and we always have on every single page of the decision, there's a header. And
Certainly.
that's not on that. So it would just be helpful to get some clarity on that. And frankly, I'll say moving forward, don't ever, make sure your office knows, don't ever alter a decision that you want to enter into evidence, because you will have questions like this, and it's utterly unnecessary. And I get that there might be difficulty fitting an exhibit number on a document because of the space issues, but I will say with all the cases that we have a lot of people that somehow manage to figure it out and find room to put an exhibit number on there. I do want to see if we can get an answer before the hearing ends. It is about 10 o'clock right now. In about 30 minutes, we will take a break. And perhaps during that break, you can see if you can get that information clarified.
Sounds good.
Okay.
We will work on that internally.
Okay, and staff can call, you can call your next witness whenever you're ready.
Thank you. Staff calls investigator Amy Roth to the stand.
Hi there, Investigator Roth. Could you go ahead and unmute yourself? Please raise your right hand with me. Do you swear or affirm the testimony you will give in this case will be the truth?
I do, Your Honor.
Okay. Go ahead and state and spell your name for us and try to speak up. It was a little bit hard to hear you there.
Sure. My first name is Amy, A-M-I-E, and my last name is R-O-T-H.
All right. I'll just give you a couple of advisements before we get started, and that is that you are not allowed to receive any assistance during the course of your testimony with your testimony, unless obviously it's a question asked by counsel or myself. You are also not allowed to look at any documents that you might have with you unless directed to do so by counsel or by me, with the exception that if you have exhibits in paper form in front of you that are called up and you're directed to look at, you can look at the paper copies if that's going to be easier for you.
Okay, Your Honor.
Do you understand and agree to these advisements?
Yes.
Okay. Counsel, you may proceed when ready.
Thank you, Your Honor. Good morning, Ms. Roth.
Good morning.
Where are you employed?
I work for Public Utilities Commission investigations for transportation.
And how long have you been employed there?
2 years.
What is your position?
I'm a criminal investigator.
And what are the responsibilities that you have to do as a criminal investigator?
It's investigating carriers, including tow trucks, limos, taxis, Uber, Lyft, and moving carriers as well for various violations.
Do you have any prior work experience in law enforcement?
I do. I've been in law enforcement for over 17 years, including narcotics detective, patrol officer, senior investigator for the DA's office, and criminal investigator for this position.
Thank you, Investigator Roth. Can you please describe your involvement in this proceeding?
Yeah, I was present for the airport portion that Investigator Hazlett discussed. And on June 14th, she had asked me and reached out and asked me to contact this carrier style car to set up the sting investigation via email and go to their website and submit a request in that form.
Can we please pull up what's been marked as staff's hearing exhibit number 103? What is this, Investigator Roth?
That is the report that I submitted to Investigator Hazlett.
So you recognize this exhibit?
Yes,
How are you familiar with this exhibit?
I wrote it.
And are investigator reports kept in the ordinary course of regularly conducted business by the PUC?
Yes.
And do you recall when you wrote this report?
I don't recall exactly when I wrote it. I just remember it was close to those dates listed in the report. So probably the 18th or shortly after.
Okay. Your Honor, at this time, staff would move to admit what's been marked as hearing exhibit number 103.
Hearing exhibit 103 is admitted into evidence.
Thank you. Could we please scroll, could we please zoom into this document a little bit? Just so it fills the entire page. Okay. Investigator Roth, do you see that message in italics in your report?
Yes.
And is this the same message that you submitted in the contact us form that you had brought up before?
Yes.
Okay. And when you access the respondent's website to submit this message into the contact us form, was the respondent's website active on that date?
Yes.
When did you submit this message?
It was on the 18th around 8 a.m.
Okay. Did you receive a response?
I did shortly after, I believe it was 8:43 a.m. I did receive a response.
Okay. And what date did you receive that response?
It was the same date and it was within the hour of me sending.
Okay. So June 18th, 2024.
Yes.
Who did you receive that response from?
It was a gentleman who identified himself as Gary of Style Car Service.
Okay. And to your understanding, is June 18th, 2024 the date of violation for the violations that Investigator Hazlett included in her CPAN?
Yes.
Okay. Your Honor, may I please have one moment to consult with my co-counsel?
Yes, you may.
Thank you. Investigator Roth, was this your entire role in this investigation?
Yes, as I said previously, I was also present for the DIA group investigation that Investigator Hazlett referenced, but this is the particular role that she asked me to play in this investigation.
And no further questions. Thank you, Ms. Roth, for your time.
You're welcome. Thank you.
Give me one moment here. I might have a question for you. I just need to check something first. So just bear with me. You know, your attorney might have covered this, but I just want to make sure that the loop is closed. So we talked about hearing exhibit 103, and I don't know that we need to pull it up, but it was your summary of your notes about the email that you were going to send through Style Car Services website to request service using your alias. And in those notes, you even summarized what the response was to it. So just to close the loop, hearing exhibit 104, let's go ahead and just pull that up. Again, might have been covered. I just want to make sure we connect the dots on the record. So once we get hearing exhibit 104 up, you can answer just so that we close the loop, but I'll just tell you the question is this the email response that you were referring to in hearing exhibit 103?
Yes, Your Honor.
Okay, thank you.
Thank you.
That's all I wanted to ask. Counsel, you're welcome to do any redirect if you have any.
Yes, Your Honor, briefly, and I'll keep this exhibit up. This is hearing exhibit 104. Investigator Roth, do you see the email at the top of this page, Jamie Smith?
Yes.
Is that your alias that you use as part of your investigation?
Yes.
Okay. And just to confirm, that's jmirieles@gmail.com?
Yes.
Okay, thank you. Staff has no further questions.
Okay, thank you, Investigator Roth. That will conclude your testimony, at least for now.
Thank you.
Counsel, we've got about 15 minutes before our morning break, but let's just push through. You can go ahead and call your next witness. I think you have 3 witnesses listed.
Your Honor, staff has no further witnesses and we rest.
Oh, wonderful.
Thank you.
Then I guess that'll save us the time of having to take a quick recess, though. I'm not sure you might need a little bit of a break, and then we can come back and address the question about hearing exhibit 111. But you know what, before we do that, let me just run through for you the exhibits that have been admitted into evidence. Let's see, I've got hearing exhibits 100 and 100C, 101 through 105, and then I've got 111 and 113. None of the other exhibits are admitted into evidence. That's 106 through 110 and 112. Those have not been admitted.
That is accurate on our end, and that is what staff intended to admit.
Okay.
Thank you.
Okay, all right. Well, why don't we go ahead and take our morning recess, and then hopefully when we can come back, we can just get a little bit of clarity on the preparation of a hearing exhibit 111. And then we can adjourn our hearing if we're ready at that time. All right, so it is 10:15. We'll be in recess for 15 minutes until 10:30. The webcast will continue during that break. So please be sure to mute yourself. All right, thank you. Okay, we'll go back on the record. 10:30 now. I also just want to note for the record that respondent and nobody on respondent's behalf have appeared since we started the hearing at 9 a.m. So let me turn to staff. Do you have any updates for me?
Thank you, Your Honor. And I don't know if it's just me, but I can't see you.
Oh, hold on a second.
Okay. Oh, there you go.
go.
Yeah.
I had it turned on, but I forgot I have a cover over that. So.
No problem. And yes, Your Honor, I did consult with our internal team, and I will just note for the record that it is not staff's practice to edit exhibits in any way. So this was inadvertent, the lack of the headers. All we can say is that this document is from the Colorado PUC filing system, given the red letters on the left, that the contents are accurate, and that the lack of headers was an inadvertent mistake. And we'll make sure that we'll keep an eye on whether any changes like this happen again in the future. But I unfortunately don't have an answer for you as to what exactly occurred here, but can tell you that it was not deliberate.
Okay, well, you mentioned the red filing notice. Okay, so I was just looking at that. And it is there on page 1. So, and that's a reference to where it says Colorado PUC filing system to indicate that's where it came from. So, okay, well, I appreciate that. I don't, look, staff appears in front of me all the time. I haven't seen staff do this, so I don't want to imply, I don't intend to imply staff did anything wrong, there was any kind of intentional wrongdoing at all here. If anything, it just looks like it was a mistake that was made, but it is not one I want to see again. So as long as we're all on the same page there, I think we're fine. I don't really think
Understood,
there's
Your
any
Honor.
question about the authenticity of the document. There's evidence and testimony about that, so I'm comfortable with that. Okay, so with that, is there anything else that we need to address before we adjourn our hearing?
Nothing further from staff. Thank you for your time today.
All right, thank you for your presentation, and we will adjourn our hearing. I will issue a written recommended decision in due course. Have a great day.
Thank you.